Welcome to our webinar on charity trustees and potential employment issues. I'm here with my colleague Sonya, who's a partner in our employment team.
Hi there.
Sonya and I recently both wrote an article on the difficulties with the concept of suspension in relation to charity trustees. And we've had quite a lot of response to that article, which is why we thought we would delve a little further with this webinar. We may not cover everything that you would like us to talk about, so there are our contact details on the screen, so please do get in touch with us if you have any questions. Today we're going to cover the status and role of charity trustees, employees and volunteers. And then we're going to look at a recent case which considered how the different roles can easily become confused and the effect that that has in respect of employment law. And to finish up, we're going to pull out some key points for charities to consider. So firstly, let's look at the status and role of a charity trustee. The role of a charity trustee is a functional one. And by that, I mean that you don't become a trustee by virtue of the title you're given, but by virtue of the role that you undertake. So your title might be different depending on the structure of the charity or the sector in which the charity operates. For instance, you might be called a charity trustee, but equally, you might be called a director, for instance, if the charity is a company, or you might be called a governor. That can be the case if the charity operates in the education sector. Alternatively, collectively, the trustees might be called the council or the management committee. Whatever the title is, the important factor in determining whether or not you are a charity trustee is actually the role that you play within the charity, and specifically whether or not that role meets the definition of charity trustee, which is set out in the Charities Act. So that definition is found within section 177, and that requires a charity trustee to be the persons having the general control and management of the administration of a charity. What that boils down to is that if you're responsible for the overall strategy and direction of the charity, if you take decisions which affect the charity as a whole, then you probably are a charity trustee. Importantly, since the role of a charity trustee is a functional one, it is possible for someone to think they're not a trustee when in fact they are. And a recent example of where this was considered was in the case of Kids Company. Now, you might remember that Kids Company became insolvent in around 2015, and the official receiver brought a case against both the trustees and the CEO, accusing them of negligence, lax financial controls, and a reckless business model. And the judge in that case had to consider whether the CEO, who was Camilla Batman-Gelage, should be treated as a trustee of the charity, or in that case, because it was a charitable company, whether she was a de facto director. And the reason he had to consider that was because of the centrality of her role. She was the founder of the charity. She had operated the business model. She had executive responsibility for the charity's finances. She was the public face of the charity. And she and the executive team had the most significant role in developing the strategy, with the board being less involved. There was a suggestion during the case that the majority of the decisions were made by her and were often predetermined. But the judge actually found that Miss Batman-Gelage was not, in fact, a charity trustee. In his words, she was simply a very effective and strong CEO, operating under broad delegated authority of the Board of Trustees, without significant interference from them, and that was fine. So whilst she had significant influence, they did not treat her as if she was one of the trustees, and they remained the ultimate decision makers. That was the crucial point. So charity trustees are usually appointed and removed, and that appointment and removal is usually provided for within the governing document of the charity. As Sonya and I discussed in our article, there isn't generally any scope for suspending a trustee. For example, if they decide to take some time off to care for a family member, if there's been a bereavement, or if there is an ongoing investigation into an allegation against them. The trustee role is a functional one. So if they are performing the functions of a trustee, then they are a trustee. And if they stop performing the role of a trustee, then they should either resign or be removed from the governing body. Suspension is specifically an employment law concept, and it doesn't work alongside the principles of trusteeship, which I'm going to talk about now. So the role of a charity trustee is based on a fiduciary relationship. Put another way, that means it's a relationship of trust and confidence. So the role of a trustee is a voluntary one, and the distinguishing obligation is one of loyalty. And that gives rise to various duties, which I've set out on the screen. These are taken from the Charity Commission's guidance, CC3, the Essential Trustee. And if you haven't had a look at that, I do recommend you have a look. All of these duties derive from the fiduciary relationship. And the overriding rule is that the trustee must not place themselves in a position where their own interests conflict with those of the charity. They must always act in the best interests of the charity and show undivided loyalty to it. They must not profit from their position as a trustee. And that is called the no conflict, no profit rule. So how that usually plays out is that trustees are not usually paid for their time acting as a trustee. They can receive certain payments from the charity. They must be authorised either by the governing document, by statute, or by an order of the Charity Commission. So it's quite unusual, although it isn't impossible, for charity trustees to be employed by the charity. You can easily see that if they were employed, it would be really difficult for a trustee to take a decision in the best interests of the charity if that decision might also impact on their employment. So that no conflict rule would be really difficult to uphold in that situation. So as I said, the law does allow charity trustees to receive certain payments, but they are usually quite restricted, and I've set them out briefly on this slide. What the governing document will usually expressly exclude is remuneration for employment. So let me now hand you over to Sonya, who will take a look at the employee's role and how that differs from that of a charity trustee.
Thank you, Nicola. Yes, let's have a little look at that then, because this is an area that does cause quite some difficulty sometimes for charities, and it can be a real area of risk as well. So understanding what somebody's role is within a charity can be really vitally important. And I'll come on to talking particularly about trustees in a moment, but I think it's really useful if we start off by setting out a little bit of detail about what the employment law provisions are around the status of different people who might engage with the charity. Now, the gold standard when it comes to employment protections comes for those people who are deemed to be employees. Now, on the face of it, that's normally fairly clear because somebody will have signed a contract of employment at the beginning of their engagement, and that will set out all the terms and conditions that they're entitled to. So in theory, at least, it should be quite clear who is an employee and who is not. However, in practice, things aren't quite as clear-cut as that, because regardless of what's set out in writing, it can be the case that people have become an employee over time, perhaps because of the way that they were treated. And it's very similar to that Nicola was just speaking about, to do with the functional role of a trustee. Well, it's very similar with employment status. It's really about the functions and the way in which somebody is operating that will determine, alongside any documentation that's in place, but that will determine what sort of status somebody actually has. So with employment status, then we have the gold standard, which is an employee. We have a hybrid sort of middle ground category of somebody who is a worker. And that was a concept that originated from European legislation, but which has become very much assimilated into England and Wales in the legal provisions that we operate within. And under Section 233 of the Employment Rights Act, 1996, there is a definition of a worker. And it's defined as somebody who has entered into or works under a contract of employment or any other contract, whether expressed or implied, whether oral or in writing, where the individual undertakes to perform personally any work or services for the other party. Now, that's the strict legal definition of a worker. And that really then sets out a variety of different factors that are looked at if an organisation and a charity might be trying to decide whether somebody is entitled to the whole suite of employment rights and protections from unfair dismissal, protections under the Equality Act from not being discriminated against, and the right to national minimum wage, etc. Some of those rights only attach to an employee, and particularly the right not to be unfairly dismissed. A worker would be entitled to the national minimum wage, protection from discrimination, and a whole host of other health and safety protections and a variety of other rights, but not unfair dismissal protection. So if somebody is carrying out work in a particularly personal way, so they themselves are the one that is obliged to carry out that work, and there's an obligation on them to turn up for work if they're asked to do so and carry out that work themselves, then it may be that they're actually more of an employee than a simple worker. However, on the flip side of all of that, then we look at whether or not somebody is genuinely self-employed, and that would be that they're carrying out services for an organisation, for a charity, but they're doing that very much of their own will. It's a contract for service where they're providing their services in the way that they choose and charging a fee perhaps for those services. And that would be the normal position with somebody who is self-employed. The charity couldn't exert any particular control over how those services are provided, when, where, and what is actually done. It is simply that they would contract to have those services provided in whatever way the self-employed individual wishes. And that then brings us on to volunteer status. Now, a genuine volunteer is entitled to provide some support and engage with the charity as they wish. They are not entitled then to necessarily receive pay for that. It is normally something that is a freely given service, and there would be these lack of these key factors. A control by the charity to the volunteer is lacking normally in a genuine volunteer arrangement. So the volunteer is entitled to provide their support and carry out some work really in whatever way they see fit. There wouldn't be that same requirement of personal service and that mutual obligations to, if you're provided with a shift, you must do that shift, otherwise there is a sanction that could be imposed. For a genuine volunteer, those sanctions should not be in place, and there isn't really any particular tight obligations between the parties. And if that's the case, then a volunteer is genuinely a volunteer, and that would be the case normally for a trustee who is not being paid a salary and expected to be an employee as well as a volunteer, which Nicola said comes with some challenges. And if someone is genuinely a volunteer, they're not entitled to the national minimum wage. There is limited protection from them in any respect, with regards to any protection from discrimination, for example. So that is where most charities wish their volunteers to genuinely sit, so that they don't have the same protections and rights, because otherwise their financial model of how the charity is set up could be very different. I think it might be really quite useful if at this point we look at a case which sets out some examples of when these sorts of things can go wrong. And I suppose one of the things to think about is that these issues tend to only arise, a challenge around employment status, if a relationship has broken down between the parties. So if a volunteer is no longer feeling valued by the charity that they have provided their service to, for example, then they may start to look around to see what other type of employment status can I claim, which might give me some particular protections and rights that I otherwise hadn't had as a volunteer. So in this particular case, Martin Groom brought a claim against the Maritime and Coastguard agency. This is a recent case. It was in February of this year. So it is really quite a recent case that sets out some of these sort of challenges and hopefully will flag to you some of the issues to be alive to in preventing falling into the trap of a volunteer becoming something other than a genuine volunteer. So a few of the facts then. The Coastguard Rescue Service discharges some of the functions of the Maritime and Coastguard Agency across the UK. And that rescue service is made up of a number of different rescue teams. And within those teams, there are approximately 108 employees, or there were at the time this case was heard, and a huge amount more volunteers. 3,500 volunteer coastal rescue officers, or CROs, and also station officers. So that's when a coastal rescue officer is perhaps promoted out of that role into more of a managerial role, managing a team of other volunteers, but still, in theory, classed as a volunteer themselves. Mr. Groom was one of those coastal rescue officers from 1985, and then he moved into a station officer role in 2011. In 2020, though, relationships had started to fracture, and he was invited to a disciplinary hearing. And following that disciplinary hearing, his membership of the Coastguard Rescue Service was actually terminated with immediate effect. Mr. Groom then wanted to try to say that he was actually something other than a genuine volunteer. He wanted to show that he was actually a worker and therefore entitled to a variety of protections, one of which would have been the national minimum wage for the time he'd worked. But also, particularly, he was claiming the right to have been accompanied at a disciplinary hearing, which is a right that only attaches to a worker or indeed an employee in those sorts of hearings. So one of the main issues for the Employment Tribunal to grapple with was whether or not the volunteer agreement that was in place with the Maritime and Coastguard Agency and the written down code of conduct that they had, whether those documents actually provided Mr. Groom with particular rights which made it more likely that he was a worker than a volunteer. The Employment Tribunal actually, at first instance, decided that they didn't think that Mr. Groom was indeed under any kind of contractual obligation to the agency. And that meant that they felt he wasn't a worker. So they thought that he was acting in a genuine volunteer capacity. However, he appealed that decision, and the appeal was heard by the Employment Appeal Tribunal, and his appeal was allowed. And in that particular case, what the Employment Appeal Tribunal did was to really look in more detail at the documentation that was in place and also what was happening on the ground in terms of the way in which Mr. Groom was providing his services. In those particular documents, particularly the volunteer agreement, there was actually a clear right given to remuneration, so a form of pay in respect of certain activities that those volunteers carried out. Now, that isn't normally in line with volunteer status, where actually, other than genuine expenses for work carried out, you wouldn't normally expect to see pay for a volunteer. Whereas in the documentation, there was actually a variety of different factors that were set out that said when pay may be awarded. And it was linked to time undertaken in carrying out duties, travel, and genuine expenses. But under time, it was broken down actually into a number of categories where an individual volunteer may choose, if they wished, to claim some form of pay. And broadly, it was broken down into the ability to claim for an hourly rate for certain functions. Not everybody did claim, because some volunteers genuinely wished to see that service continuing and knew that if they claimed for their pay, it might become financially unviable. However, there was this opportunity for pay, and indeed at the end of the year, if somebody did receive pay as a volunteer, they actually could have their P60 issued, and ultimately on the end of any relationship with the agency, a P45 was issued, all of which points far more towards more of a worker or indeed employment status. And indeed, in this case, that's what the Employment Appeal Tribunal determined. Mr. Groom, regardless of the fact that he was supposed to be a volunteer, and that's what the agency had hoped he was under the volunteer agreement, actually the way he worked was far more in line with being a worker when he attended the activities that he was being asked to carry out. So, and it's all around that fact of money that was being paid to him, which was far more in line with a worker status than a genuine volunteer. I think the other little quote that I've set out there on the slide is worth bearing in mind. And this is from a case in the Citizens Advice Bureau and Grayson, a case that goes back to 2004, but it is still good law. And it's a point that really shows that actually, regardless of what you might put in writing, if actually the relationship on the ground is one that's more like an employment or a worker relationship, then that is what will have become the case. And so it really is a functional analysis on each case-by-case basis to understand whether someone is genuinely a volunteer or not. And pay is actually quite a key factor there. So that's really worth bearing in mind. And so for trustees, the issue of pay really ought to be, unless they have particular employment rights and then there is an intention to create an employment relationship for which Charity Commission approval may be required, then it's really important that the only pay that's being offered really would be genuine compensation for expenses that have been incurred. Other complexities can really arise if that's not the case. Nicola, over to you.
Sonya, thank you so much. So now let's try and wrap all of this up and bring it all together with a summary of key points for you. What should you be checking regarding who is a charity trustee, what their duties are, and how to avoid that awkward territory between a worker, an employee, and a volunteer? So firstly, check your governing document. Is it clear who your charity trustees are? What are the appointment provisions? Are they clear? Do you have a description of the trustee role? Do the trustees have the power to delegate their duties to committees or individuals, and how is that delegation monitored? Does your charity have employees, and are any of the charity trustees also employees? And if so, has that been properly authorised? Remember, the trustee role is a functional one, so who are the ultimate decision makers in your charity? Secondly, do check the other documents that you might have in place. So things like codes of conduct and volunteer handbooks. What are the provisions within those? Is it clear what the obligations are for volunteers? And are there any remuneration provisions which might create that worker relationship that we saw for Mr. Groom? Thirdly, always remember your trustee duties. Make sure that you can identify conflicts of interest and loyalty when they arise, and make sure that you can deal with them appropriately. There might be provisions within your governing document that stipulate how to do that. For instance, removing the conflicted trustee from the meeting and making sure they don't participate in decision making. And if that's not possible, if you can't deal with the conflict of interest in that way, then you might need an order from the Charity Commission. And lastly, what payments are being made? What remuneration is being provided to the charity trustees? Is it solely expenses, or is it more than that? And if it's any payment for services, is that covered by the statutory provisions, or do you have other authorization for it? So that's the bulk of our webinar. I hope that's been helpful. We did have one question which was sent in to us in advance, which I thought we would just answer in brief now. And that was, how do you keep trustees in the governance strategic space rather than in the operational details space? And that is definitely a situation that many charities find themselves in, managing that crossover between strategic and operational issues. Firstly, I think it's worth pointing out that a trustee's involvement is really likely to depend on how large or small the charity is and how new it is. So for newer and smaller charities, it's far more likely the trustee will be much more hands-on. Where a charity is larger, and certainly where it has employees, you would expect them to be delegating the operational issues down to their members of staff. And there should certainly be provisions in the governing document providing for that. The trustees would then have a much more strategic overview, and they should be receiving reports from their staff on operational matters. Sometimes there is a tension where trustees overstep into operational matters, and that probably boils down to one of two things: either their lack of understanding of their role, or potentially also the issue of reporting that I just mentioned. So in terms of understanding their role, trustees should operate within their fiduciary relationship, and they really do need to understand what their duties are. So it can be helpful having documents which set out the roles of the trustees and the roles of the various delegated individuals. So for instance, if you can point to job descriptions, that's really helpful. It can also be really helpful to have a really good trustee induction process and ongoing trustee training. And if some trustees are particularly difficult in this regard, then mentoring can be helpful as well. And then the second issue of reporting, where a charity gets bigger and more of the operational matters are handled by the employees, reporting back on those matters to trustees is key to ensuring that trustees have all the information they need to really operate at a strategic level effectively. So sometimes having the CEO and senior management attending trustee meetings is helpful, but if not, then definitely making sure that documents reporting back on what is going on is a requirement. That's really vital for trustees to be able to fulfil their obligations under charity law. So thank you very much for attending our webinar. We do hope it's been useful to you. Do check out our articles and the previous webinars that are available on our website, and please do register for future webinars. We really look forward to seeing you again, and thank you again for attending.
Thank you so much.